Hello and welcome. We are going to give everyone a few minutes to sign in and then we will begin. Okay, welcome everybody. This is part 2 of our Parent and Caregiver Resources series. Last week we discussed waivers and funding sources, and this week we are going to be discussing guardianship and its alternatives. As far as accommodations, we have an ASL interpreter that is on screen who, along with our moderators and panelists, will be providing ASL interpreting, and then we also have captions available as well. So you'll see that option in your bottom right corner or bar of your screen. You can click on that if you'd like closed captioning as an option. We will also have the webinar recorded, and it will be available both on the Ability Center's website as well as the Lucas County Board of DD's website. I am Dawn Bentley, and I am the Director of Youth and Transition Services at the Ability Center, and I am joined by Heather McVeigh from the Lucas County Board of Developmental Disabilities. So without further ado, yes, thank you, Heather. Without further ado, I am going to introduce our 2 amazing panelists that we are thrilled to have here with us. We have Judge Puffenberger. Judge Jack Puffenberger is currently the presiding judge of the Lucas County Court of Common Pleas. He has been the presiding and administrative judge of the Lucas County Common Pleas Court Probate Division since 1991. Prior to this, he was twice elected as judge of the Toledo Municipal Court in Toledo. He's currently a member of the Ohio Judicial Conference Executive Committee, where he co-chairs that organization's Probate Law and Procedure Committee. Judge Puffenberger is also a member of the Executive Committee, and he's a past president of the Ohio Probate Judges Association, as well as currently serving on the Judicial Advisory Committee. He's a former trustee of the National College of Probate Judges and a former member of the Board of Governors of the American Judges Association. He has served on the Ohio Supreme Court Board of Commissioners on grievances and discipline and the Ohio Supreme Court Commission on the Rules of Practice and Procedure. He is currently a member of the Executive Committee of the Lucas County Bar Association and president of the Toledo Legal Aid Society. So all of that is to say, Judge Puffenberger knows his stuff, and we are thrilled to have him here. We also have Maggie Scotes with Disability Rights Ohio. Maggie is currently a staff attorney at Disability Rights Ohio on the short-term assistance team. Her casework largely consists of guardianship, voting rights, and mental health. Prior to her work with DRO, she was the Saxby Fellow at the Ohio Attorney General's Office and interned in guardianship and mental health for the Alaska Department of Law. So as you can tell by given their biographies, we have 2 of the experts in the field here, and we are thrilled to ask them all of the questions that we need answered as far as guardianship and the alternatives for parents and caregivers. Heather, if you'd like to begin.
Absolutely. Welcome to both of you, and thank you again for being here with us. I'm excited to hear all of the things that you have to share with us today, as I'm sure all of our guests are too. So we'll start off with the big question, which is, what is guardianship? What does that even mean? Can you guys share a little bit about that?
Well, I can share a little bit. those of us in law always try to get involved with real detailed definitions and that sort of thing. I'm going to try to stay away from that today and try to explain things the way they are. But first of all, I would like to really thank the Ability Center and the Board of Developmental Disabilities for providing this forum. And I really appreciate Maggie Scotis being here from Disability Rights. We spoke the other day. She does have terrific information, and that organization does a wonderful job. So I want to thank people before we begin. But guardianship, basically, I mean, its basic form is a court-ordered relationship wherein one adult is authorized by the court to act on behalf of another adult. That's kind of it in a nutshell. There are all kinds of fancy definitions, but that's what it is in a nutshell. Maybe Maggie want to go in a little more detail on that.
Yeah, so guardianship is a legal process that exists in the state of Ohio that allows a person with a disability who has difficulty making decisions or making good and safe decisions to get a court-appointed party to assist them in making decisions. And that can be a member of their family, it can be a friend, it can be a third party. There are a lot of different options, and not all guardianship looks the same, but it is a court process, and it's something that's reviewed by the court and maintained by the court as well.
So you guys have both mentioned the court quite a bit. Does that mean that parents would need, or someone would need, an attorney, either the parents or caregivers or the person with the disability when guardianship comes about?
Well, as far as the necessity of an attorney, you'll find that sometimes there are different rules in different counties, and people operate differently. As Dawn mentioned, I'm not only the administrative judge of the probate court for over 30 years. I'm the only judge there. So it's we have our rules kind of set. And in our court, we do not insist that the applicant have an attorney. The applicant may or may not have an attorney. We have a pretty good system in Lucas County in that as far as having an attorney, we have an agreement and relationship with the Toledo Bar Association. And those of you out there watching who have a pen and pencil with you, if you need help filling out any forms and you want to proceed without an attorney, the person at the Toledo Bar Association to contact is Michelle Tussing, Tussing. Michelle Tussing runs the pro bono program at the Bar Association, and there are attorneys who are willing to help you put together forms at no cost, pro se. They will do. The Bar Association just provides that service. And so that's a very good answer to that. With regard to an attorney for the proposed ward, I'm gonna let Maggie speak a little bit more on that, but the proposed ward has certain rights, and counsel is certainly a right. And Maggie, maybe you want to cover into that a little bit.
Yeah, absolutely. So in the state of Ohio, the person who is potentially becoming a ward of a guardianship does have a right to counsel. So that means that first of all, you can be present at your hearings, and you have a right to be present at your hearings if you choose to. You also have a right to have counsel present and consult with you prior to the hearing to help prepare your defense. If you cannot afford to have an attorney, you do have the right to have the court appoint an attorney to represent you in those proceedings. And so that's one of the things at DRO a lot of people don't understand or know that the ward has a right to an attorney. And so that's one of the things we always make sure to let people know is they do have a right to an attorney. And if you need help requesting an attorney, we do have a form at Disability Rights Ohio that is easy to fill out and will allow you to request an attorney from the court so that you can have representation at your hearing.
Wonderful, thank you both. So how does somebody get started even to apply for guardianship?
Well, guardianships, as Maggie said, are pretty much form driven. Every county has forms. Most of the forms are standard state of Ohio forms, which courts put their own title and judge's name on top. So they get, people see their name, I guess. But the forms are mostly state approved by the Supreme Court of Ohio, and it's form driven. Basically, everything's a little bit different right now in the COVID situation, but basically the application for guardianship needs to be filed with the court, signed by the applicant, and that that application must have other documents with it, but most importantly, it must have a statement of expert evaluation. There has to be a statement of expert evaluation. And that statement of expert evaluation, the initial one, has to be filled out by a licensed physician or a licensed clinical psychologist. People in the law like me, I mean, we have some knowledge of the law, but we're not trained or skilled in those areas. So we rely on experts in those areas. So the individual who's the subject of the proposed guardianship needs to be examined, and we need a report from one of those two types of physicians to as to whether or not, in their opinion as a professional, whether or not they believe a guardianship is necessary. And that's not totally determinative. The determination is made by the court. That's certainly a huge piece of evidence. But it's a very important piece. And that's basically how it begins. And then once the documents are filed, the court proceeds at that point. And Maggie, maybe you want to add to that?
Yeah. So one other note about the independent evaluation is the initial evaluation needs to be done within 90 days of the filing of the case. You cannot use an independent evaluation that was from prior to 90 days. And then also the ward additionally has a right to have an independent evaluation of their own conducted, so they can present alternative evidence to rebut the independent evaluation being done by the petitioner. And then another question that we often get at DRO is what the timeline looks like for that. So it depends on court schedules, obviously, but we tend to say that from the time that you file, you can look at about 3 weeks to a month to see the visit from the court visitor and get that first contact. And then once you have that done, it can be 3 to 5 months, depending on court schedules again, before you actually have the first hearing in guardianship. That can change if you have an emergency guardianship going on, but generally we tell people that that's kind of the range to look at from start to finish.
Wonderful.
Well, I would mention there that the courts once again are different, and I'm not here to brag about my court, but we move much quicker than that in our court. I'm not saying I'm a great judge, but I do have a great staff. We have some really good people, and our court moves a lot faster than that. And the issue is that, you know, in some of the smaller counties, the judges have a responsibility over juvenile court and probate court. In the larger counties, we have a probate judge who does only probate. So in my court, since we're in a larger county, Lucas County, we only do probate. We focus specifically on that. So our process is much quicker. And the timing of that, I'll mention also, one issue that comes up with individuals with developmental disabilities is they're going to be 18 pretty soon. What do I do? And as Maggie just said, in some of these counties, it takes a while. So our court does allow applicants to file the guardianship application prior to the 18th birthday. You can file that several weeks ahead. We normally have a hearing within a month. So you can file that, and then we can schedule that. I mean, even on the individual's birthday or after the birthday, so it's seamless that the guardianship is in place when they reach the age of majority. So you can file that before they're 18 in our court, but we will schedule the hearing after they're 18.
Judge Pfeffermaker makes a really good point about the difference between counties. So I practice statewide. And so a lot of the advice I give is kind of an average across the 88 counties that I see. And every county does do it slightly differently. There are some counties where you cannot file until the day after the person turns 18. So it's a good idea to get in contact with the county court that you're in and see what their guidelines are to figure out what that timeline is going to look like for you and your family potentially.
That's very true. Thank you.
Great points from both of you. Thank you. So what is the overall role of the court? I've heard you guys both mention the court multiple times. What is the role of the court when guardianship is involved?
Well, I can tell you that the court's role changes during the process. And initially, when a guardianship and people need to realize the court is not a social service agency. We're a court. We make legal determinations. We don't provide services, but I mean, we don't provide services for individuals for their care. But so when a guardianship application is filed, the court is strictly working in a legal capacity. We're making legal determinations. We want to ensure that the proposed ward's rights are being followed. We send a court investigator out when the application is filed from our own court. We make sure if someone is requesting an attorney that we get that done. We make sure that all the rights that Maggie was talking about earlier, and she should be talking about some other ones, I assume, that those rights are heeded, that we're making sure that that person's rights are protected. And then in a hearing, we are still independent. We have no position in this. We're not anxious to have anyone under guardianship. In fact, guardianships are not favored in the law. I mean, basically, our preference is to have people make decisions for themselves. And maybe they can't make some decisions, maybe they can make other decisions. So we're trying to make a legal determination and you'll hear the term a lot, and I'm sure although you are watching the webinar are familiar with this term, what's the least restrictive alternative? And Maggie will get into that with alternatives and things. But I mean, the court is making a legal determination. When we order a guardianship to take place, that's a legal determination. We have determined that that person is incompetent and they need a guardian, and we've appointed a guardian. Once the guardianship is in place, the court's role changes. At that point, we become the superior guardian of the ward. Even though one of you will be appointed the guardian, the court is always a superior guardian. So at that point, we are looking out for the ward's best interest, and we're doing that any way we can. If we're getting information that the ward's not being cared for properly, we're calling the guardian in, and we want to know what's going on. We're having hearings, we're getting reports. We change once the guardianship exists to we kind of leave our role of making legal technical decisions at that point, and we go into a superior guardian role, really. We're looking out for the ward at that point. And so that's the role of the court, as I say, changes, and that's what it is. And Maggie, you see that in different places too, I suppose.
Yeah, absolutely. And the role of the court in terms of making legal determinations, there's kind of two roles that are going on, especially at the initial guardianship phase. The court's determining A, if the proposed ward is suitable for guardianship, if it is the least restrictive alternative available, and B, if the applying guardian is suitable for guardianship. And so the court's making both of those determinations. And so you'll sometimes have cases where one or more people are applying for guardianship, or a guardian is applying but may not be found to be suitable to be a guardian. And so another role the court plays as this goes on as part of their superior guardianship role is they make sure that the guardian is doing their duty. So make sure that they have the correct education that they need, make sure that they're filing the reports that they need, all of that sort of stuff, and are also there to assist if there are disagreements that concern the ward's rights during the process of the guardianship. So if a ward believes that they are no longer being given the rights that they deserve under guardianship, they can go and petition the court and file a complaint to request the court review the action of the guardian and see whether or not it's appropriate or not.
That's true, and I should have said that also. Yes, we do still have some legal determinations that come down the road when there are different issues come up, and sometimes even guardians seek guidance from us. And we were talking the other day that one of the things right now is COVID vaccinations, and we have guardians calling us saying, "What do I do? My ward doesn't really want to get a shot, but I think it's best for them." And I mean, this is a big topic we're going to talk about today, but those type of issues come up, and what do you do? How do you balance that? And I'm sure you'll have questions further on, but the court does get involved sometimes in those type of decisions. And as Maggie said also, the guardian needs to be suitable. You say, well, why wouldn't I be suitable? Well, there are different reasons. First of all, in every guardianship application, we run a record check. I mean, I can tell you right now in Lucas County, and I hope every county, if we run a record check and a person has a record of convictions of assaultive behavior, things like that, we're not appointing them the guardian over anybody. I don't care who they are. They're not, I'm not going to put somebody in charge of somebody's well-being if they have a history of assaulting people and that type of behavior. I'm not going to do it. And some of our guardianships involve monetary responsibilities. And if someone has a criminal history of theft or something like that, they're not going to be a guardian of over somebody's money. So a record check is one thing most often that would make somebody unsuitable.
Okay. So can both parents be guardians of a child? Is it one, the other? How does all of that work?
Well, we here we go again, but different counties are different, I suppose. In Lucas County, we strongly discourage that. We strongly discourage co-guardians. Some counties won't even allow co-guardians, but we have yielded occasionally, but we don't like it. And the reasons for that are multiple. One is sometimes, like if medical care is needed, some hospitals or medical providers may require the signatures of both guardians, and maybe one is not available. And so they say, we're not, there are two guardians, we want both of them to sign. We're not going to do it. So that's the problem. And also, as Maggie mentioned, sometimes the guardians, if they're co-guardians, they don't agree between themselves on what should be done. And then the court has to step in, and we have more problems with co-guardianships than we have positive things, in my view. But Maggie, if you could comment on that also, I'm sorry.
Yeah, this is a common question that we get at DRO a lot. And it's also important to mention that having co-guardianships, especially if there's disagreements between the guardians, runs the risk of eventually just having a third-party guardian appointed, which can be really upsetting to some families, because then you have someone who's not even a part of the family making decisions for the ward. So that's a consideration to make. There are some counties that do allow co-guardianships, and I have seen cases where co-guardianships were effective, but it's not something that I recommend to people generally, because it does run the risk of having significant conflict in the case and or leading to a third-party guardian down the road.
Okay.
And our court has done that on a number of occasions when we've had guardians, co-guardians who can't agree. That's exactly where we go. You're going to end up with an independent person, usually an attorney, who's going to be the guardian of your child. We just can't have gridlock. Someone has to make a decision here. And if the two guardians can't agree, someone else has to make a decision.
Okay, we have a two-part question kind of related to that. If you have a child that's still in high school but is turning 18 and someone wants to file for guardianship, do they file in the court where they live or where a divorce custody case is? So which court does it get filed in? And then also, is there a list of attorney recommendations somewhere?
Maggie, I know you've had that.
So yeah, the guardianship case should be filed where the ward lives. That's the court that's going to have a jurisdiction over the guardianship. And I would say be careful if there's a divorce case that preceded the guardianship as a child reaches the age of 18. If parents move to the guardianship, the probate court, and are essentially relitigating what happened in the child custody case, that can cause a lot of frustration at the court level, and lead to, once again, a third-party guardian being appointed. I'm sorry, what was the second part of the question?
If there's a list of recommended attorneys anywhere.
So at DRO, our mission is to advance the rights of the person with the disability. So we generally do not advocate on behalf of guardians unless it's being requested by the ward themselves. That's our mission. We will refer people to legal aid to get good recommendations, or their local bar association is a really good place to find recommendations for good counsel in probate court.
Wonderful.
Yes, I would agree with that. The court cannot make a recommendation that someone hire a specific attorney. That's their decision. But I will say that, as Maggie said, the Bar Association is a good source, because there is a certification process in Ohio, and some lawyers are certified in this area, and that means they have special expertise. And in some of these cases, it's a different, it depends on your situation. If you're talking about a straight guardianship, there may be more lawyers who have the ability to do that than if you need some kind of trust. If you need a lawyer that is more into trust planning and that sort of thing, that's kind of a different skill set. So it depends on where your guardianship's going and each individual case. And once again, maybe you could comment on that. Is that what you've seen also?
Yeah. So, and we will sometimes get contacts from attorneys who don't tend to practice in probate court requesting information about probate court practice because they know that we deal in guardianships fairly often. And again, it depends on the complexity of the guardianship. Every guardianship case is different, and that's kind of the point of guardianship. It's always supposed to be a case-by-case analysis. And so the needs of that particular case are going to determine how specialized counsel you need. There are some cases where there are a lot of issues going on in the case, and so you really should have specialized counsel. But again, it just depends on, and even if it's a contested guardianship, that's another big concern, is if it's an uncontested guardianship, you may not need counsel at all if the ward agrees to it, versus if it is a contested guardianship, and what's the basis for contesting the guardianship.
Yeah, I would back up a little bit too there, where I said earlier, the Bar Association, I gave Michelle Tussing's name and the number. They'll fill out the forms and that sort of thing. But if the guardianship becomes contested on who's going to be the guardian, that's a whole new ballgame. Then you're talking about the pro bono people are not going to be involved in that. People are going to have to get counsel and head down a litigation track.
Okay. So when you guys are talking about guardianship, does that mean if I have guardianship over my child, does that mean I have full control over everything? I get to make all the decisions on absolutely everything, or are there different levels of that?
There are different levels, and the most important one would be what's known as a limited guardianship. It can be limited two ways. It can be limited in duration. It can be limited in duties. It can be set for a certain length of time. Normally, that doesn't come into play. It's normally as the duties. And once again, as Maggie said, that there are no two cases the same. So you may have an individual who's high functioning, and they can do a lot of these things. And as I said, in the law, we prefer that people, if they have the ability to do things, they do it themselves. We don't want people making decisions for people that can make their own decisions. Other people may not be that high functioning, and maybe they need a full guardianship. Maybe someone needs to make all decisions for them. So it really depends on the individual. But my point is that these guardianships can be tailored. They can be tailored to the situation and allow someone ability to make maybe medical decisions, maybe placement decisions. Those are generally the two biggest decisions that guardians need to make. But they can be limited, and I know that Maggie has some materials on that, and may want to speak on that also.
Yeah. So Judge mentioned limited guardianships. Another term you'll hear is guardianship of the person versus guardianship of the estate. So guardianship of the person is making medical and placement decisions, where the ward lives, that sort of thing. Guardianship of the estate is making financial and benefits decisions. So it is not uncommon for there to only be a guardianship of the person, especially if the ward doesn't have a lot of financial means. Courts will often just have the guardian come back and make requests that they need to do financial decisions and just give them guardianship of the person. Additionally, even under guardianship, you don't get to make every decision for the ward. I'm actually going to share my screen here for just a second so we can talk about some of the different rights that are retained by the ward.
Maggie, when you touch on this, can you also talk a little bit about what happens through that decision-making process if there's a disagreement?
Yeah. I'm sorry, in terms of what decision-making process?
Just if there's a disagreement when making decisions basically amongst the parties between the ward, the guardian, and potentially, I know you had mentioned when we spoke, sometimes like hospital staff, for example, or medical personnel, the three parties may not agree, kind of what the process is for then coming to a decision.
Yeah, absolutely. So starting first with the rights that the ward has is wards still retain the right to be treated with dignity and respect. They are still human beings. They still have a right to have whatever they need for respect and dignity. They also have a right to privacy. That means they have a right to privacy of their body, as well as private and uncensored communication. So they can still talk with whoever they want to talk with, essentially, and make the determinations about what relationships they want to have. They have a right to remain in a safe, sanitary living conditions. They have a right to have some control over their own environment in terms of not necessarily placement, but like control their own setting. So like control the room that they live in and that sort of thing. People under guardianship retain their right to marry if they are legally able to consent to marriage. They retain their right generally to procreate and consent or object to sterilization. This is something that can come up in guardianship and does end up going to the court a lot of times, and the court will make a determination. But generally speaking, they are assumed to retain their right to procreate or consent or object to sterilization. They still have the same civil rights in terms of equal treatment and non-discrimination. They have a right to explanations of the medical procedures they're getting. So just because they have a guardianship doesn't mean that you no longer have to tell them what is going on in the medical procedure. They still have a right to know about it. They have a right to confidentiality of their personal information and to review their personal records, whether that be medical records or housing records, anything like that. They have a right to private communications with an attorney, an ombudsman, or another advocate. They have a right to drive still if they are legally able to operate a vehicle. They have a right to vote. In terms of the actual hearings themselves, they have a right to a review hearing. You can first review the guardianship 120 days after the guardianship letters are issued, and then annually after that. That changes slightly by county. Some counties will do it where you have to wait a full year before you can redetermine the guardianship, and some counties do it by calendar year. Again, I mentioned that you have a right to an independent evaluator and an attorney at court expense if you cannot afford it. And you have the right to file grievances and complaints against your guardian. The ward is not the only person who has that right. So one of the things Don and I had talked about previously was if a third party, such as a board of DD or a hospital, disagree with the medical treatment that a guardian is pursuing for a ward, they also have a right to file a complaint against the guardian if they do not believe the guardian is acting in the best interest of the ward. We encourage people to work with their guardian, the ward at least, to try and resolve these complaints if that's where it's starting. And then if the ward wants to maintain the current guardian, we also encourage and will assist a ward to maintain the guardianship if that's what they would like to maintain versus having a third-party guardian appointed. That's sometimes what we see when it comes to boards of DD or hospitals or medical facilities challenging the guardianship because they disagree with the treatment that the guardian is pursuing.
Yeah, I would mention also that as a lot of you out there know, some of these are very, very difficult calls because you have to balance between the ward's rights and your duty to protect them. And I mean, just for an example, what if your ward says, I'm not going to the dentist. I'm not going to brush my teeth. I'm never going to the dentist. And you say, well, you have a toothache. I see you have a toothache. You need to go to the dentist. I'm not going to the dentist. Well, you know, what do you do there? A lot of people don't want to go to the dentist. I don't enjoy going there either, but sometimes you have to go there. So these are the kind of balancing things, you know, you want your ward to be able to make decisions, but in something like that, where you can see they have pain because they need to have a cavity filled or whatever, you need to look out for them. It's your duty. So it's a real difficult balancing test sometimes in a lot of areas. And we get those calls, and I mean, you wouldn't believe some of the things that happen. I mean, they go to the store and buy a 24-pack of Hostess Ho-Hos, and the ward wants to eat the whole thing at one time. And then, you know, you can't eat them all right now. You're gonna get sick to your stomach. You know, different things. That's maybe a bad example, but the one with the dentist is very real. Those things happen. People, and as I said, I'm not trying to bring up the COVID shots, but what do you do right now when? I mean, I personally am terrified of needles. I hate needles. But I'm going to go get a COVID shot, but I don't like it. But what do you do if your ward says, you know, I'm not getting one. I'm not going to do it. Those are the balancing things that come up that you just have to make the call. But you should really do everything you can to follow the ward's wishes if you can possibly do that.
So that brings up a good thought, Judge. If a child is involved with the criminal justice system. Is having guardianship over them a good way to protect them?
Well, I wouldn't say it's necessarily a way to protect them, although we're doing better. But to be very frank about it, I mean, when a crime occurs and the police are on the scene, a decision's made by the police officer on the scene. And sometimes they can recognize an issue here. They're doing better training, but I mean, just because you have a guardianship doesn't mean that some police officers are going to run you in if you've done something wrong. Hopefully that can then be identified, you know, at the jail or by the police officers, and we can get the person where they need to be. And I've gotten calls from people. I've gotten calls from the jail where they've said, Judge, we have an individual here who's, you know, maybe in his 50s, and he, we don't think he should be here. You know, he's kind of curled up in a ball in the corner, and, you know, we check and we see that he's one of our wards, and we say, we got to get him out of there. We got to get him to where he needs to be. So as far as the criminal justice system, you know, I think most judges are smart enough to know that, you know, if someone's into guardianship, I think that case needs to be treated a little bit differently than someone who is competent. And so most judges can recognize that when the case gets heard. But like I say, it wouldn't necessarily prevent it from being filed, but hopefully it will help to a smoother resolution. And Maggie, I assume your group's been involved in those throughout the state.
Yeah, this is a question we get a lot. And one of the most common issues that we run into is somebody who has a guardianship and the ward has been arrested and is now in prison and is seeking medical care. And the guardian on the outside is trying to advocate on behalf of the ward to get the necessary medical care. And the prison or jail officials won't speak to them because the ward is an adult and HIPAA compliance and all that sort of stuff. And there is sometimes a lot of like breakdowns in communications and understanding with people involved in the criminal justice system. I wouldn't say from the perspective of a court involved in the justice system, but the people on the ground making day-to-day decisions about the interaction with the justice system in terms of what guardianship means and what the responsibility of a guardian is. And so that can be really frustrating for guardians who like sought guardianship in an attempt to protect their ward and are now being told, sorry, that we're just not gonna respect the guardianship. And so, yeah, I think a lot of people want it to be more protective than it is, and it isn't always. There's not going to be the assumption that because they have a guardian that the guardian needs to be involved necessarily, or that the guardianship means that they're not responsible for whatever crimes are alleged to have been committed. But there definitely is, I think, a lot of questions from potential guardians about whether or not that's a good idea for terms of protection in the legal system.
Well, I'll say too also that I mean, I think you know that, but I mean, I know it's being recorded and be played again. I say things I shouldn't say sometimes, but I can tell you that people with mental health issues are much more likely to be a victim than to be a perpetrator. Much more likely. They're almost always a victim, not the perpetrator. But anyway, that's like maybe an editorial comment. I'm sorry.
But it's
Thank you both. Oh, sorry, Maggie, go ahead.
No, sorry. That's absolutely true. We know that to be true. People with mental health and developmental disabilities are far more likely to be the victims of crime than they are to be the perpetrators of crime.
And that's a really good point to make, especially with discussing this. I'm going to actually go off script a little bit, and because we have some really good questions that actually lead into sort of our part 3, which was some of our sort of additional questions, and then we'll move into part 2, the part that is near and dear to my heart, which is the alternatives to guardianship. So we had someone ask, what is the process of making a report if someone suspects that the guardian is abusing or neglecting the ward?
That can be done a couple different ways. Normally, and once again, the courts operate differently. Normally, our court will prefer something in writing. We like to have something in our file. We like to have a complaint. We don't like to operate on telephone calls. We don't know who's calling us. We don't know what their purpose is. If they're just trying to create problems, we don't know. But if we get something in writing, I mean, we have local rules, and we will set that for some kind of status conference. We will contact the guardian. We'll say, we've received a complaint. We're setting a status conference next week. You need to be here, or a Zoom call, and we want to discuss this with you. And sometimes we'll send our investigator out to look into it. if it really is serious, we can even appoint someone independent, like a guardian ad litem almost, to go out and investigate this for the court, to be the eyes and ears of the court. But as I say, the key points there for me are we don't deal much with verbal complaints. I mean, people have different objectives and different reasons, but if you write it down, and it doesn't have to be, I mean, it can be anonymous even. I mean, if we get a complaint, if you're afraid, somebody's going to, do something to you if they find out that you complain about it. Actually, a lot of times they can figure out who it was. But if you want to file it anonymously, if we have a paper, a document that says that one of our wards is not being treated right, we're going to investigate that. We're going to look into that. We're going to get to the bottom of that. And once again, Maggie, this is what you guys do a lot.
Yeah, so we also offer, we have a standard form that we give to people. That's a complaint form that they can use to submit to a court. It doesn't have to be necessarily super detailed or super professional looking, but just to give the court an idea of what's going on and to allow documentation to be created so the court can take action. One other thing Judge mentioned was the potential appointment of a guardian ad litem. So a guardian ad litem is an attorney in the state of Ohio who's tasked with determining the best interests of the ward and making a report to the court on what that might be. So it is possible that you would have in a single case a guardian ad litem, and an attorney for the ward. And sometimes guardian ad litems are also the attorney for the ward, but generally speaking, they are two separate things, where the attorney represents the interests of the wishes of the ward, and the guardian ad litem represents the best interests of the ward.
And in a guardian ad litem situation in our court, the probate court, that's normally a temporary appointment with a very specific purpose. We will say, we got this complaint that, our ward, this is going on. We want you to look into that issue. So once we resolve that issue, then the guardian ad litem's duty is going to end at that point.
Thank you. We had another question. There's an 86-year-old mother who is currently the guardian of her 55-year-old son. His group home administrator is suggesting that she start the process of an independent guardian because of her age. So two parts to that question. One, how does she start the process? And then if you want to speak a little bit to the big question that I feel like we get most, which is, what happens if I'm a guardian for my child and I'm no longer able to care for them, or when I'm gone?
Well, this is a timely thing. I'm going to talk a little bit about this. That's an issue for everyone, and I'm not sure it's an age thing. I mean, nobody knows what their last day is going to be here. You could be 30, 40, 50, 60, 70, 89, wherever you're going to be. We don't know, but we have this happens frequently, and one of the things that we think is going to help resolve this is that we are in the process of actually coming to fruition a guardianship services board, and we have actually copied that after Franklin County, where Maggie is. They started a board there some years ago, and we actually have a meeting all afternoon today, 1 to 5. But we're going to talk about that today again. We are organizing this board. We have I organized the board by court order. We've already appointed 3 trustees of that board, and those trustees are appointments made by the Department of Developmental Disabilities, Lucas County, and they appointed Katie Hunt Thomas, who a lot of you know. She's on the Guardianship Services Board. The Board of Mental Health made an appointment to that board, an individual who was on their board for a long time, and then I made an appointment to that board. So we have 3 board members. That board is in place. They are in the process of hiring an executive director, and we're hoping to have that functional by April 1st. So this will be an alternative. So if you're concerned about this, or maybe you are getting older and feel you need to be concerned, there's no logical successor guardian if you're not there. You'll be able to look into this. This board can actually be the guardian. Up until a couple years ago, APSI was the only corporate guardian allowed in Ohio. The new statutes allow these guardianship services board. So the board will actually be the guardian. And I think it'll give a lot of people comfort to learn how this board functions, and the board could become the guardian when they're gone. That's something that's a possibility.
So as part of the question, Judge Puffenberger, we had someone else ask, can you speak to emergency guardianship? Would the board serve the same purpose in other situations?
Well, emergency guardianships come up, and they come up, and they are done what we call ex parte. We don't notify anyone. And it's a situation where something needs to be done right now, and a hospital needs to do something to save either serious injury or the life of an individual. And emergency guardianships, I issue them ex parte. We don't notify anybody if there's no guardian, and they only last for 72 hours. So when we get a call about emergency guardianship, we say, what is it that needs to be done in the next 72 hours to save this person's life or preserve them from great physical harm? What exactly is it? And maybe the hospital say, we need to put a trach in. We have different issues going on here. We're just concerned that we're not certain the person has the ability to consent to this, and we want to cover ourselves. We want a court telling us we can do this. So there's 72 hours. We can extend them for 14 days if that's necessary, but it's a very short process and very limited. We don't issue a lot of emergency guardianships, quite frankly, but it would have to be something needs to be done the next 72 hours to save that person's life or great bodily harm. And you run into those, Maggie?
Yeah, we do. We don't run into them super often, obviously, because it is a pretty high standard to be able to justify having an emergency guardianship filed. I would also note that just because you are successful in getting an emergency guardianship does not mean there will not be a full guardianship hearing down the road. There is. The court will make a determination where the ward has the opportunity to present their case and explain why they don't need a guardian or why they would prefer a different guardian be appointed in their case.
Thank you both. So I think it's a good time to talk a little bit about what are the alternatives to guardianship. I know it's something that when we talked about this webinar, we said, I think oftentimes there's this misconception amongst parents, especially parents of children with disabilities, that it's sort of an all or none type of a thing, but there's so many options out there that I don't think a lot of people are aware of.
Maggie, go. This is your field.
Yeah. So we've mentioned a couple of times that to establish a guardianship, you have to show that it's the least restrictive alternative. So the least restrictions on civil rights that will keep the ward safe. Anything less than that would not keep the ward safe, essentially, is the standard you're trying to meet when showing that somebody needs a guardianship. So I'm going to share my screen again, and I'm going to show a couple of different options that we talk about in terms of different guardianships. So when we're talking about the continuum of support for decision making, there are lots of different options that come prior to guardianship. So one that is really easy to understand is just informal support and assistance. And that is something that everybody gets. You do this with your family when you're talking, especially as you're a young adult, when you're deciding the first time you're going to buy a car or buy a house or whatever. You talk to your family about it. You talk to your friends about it. You talk to people that you respect and whose opinion matters to you in terms of making good decisions. There's also a process called supported decision making, which is a more formalized process in some states. There's not a formalized process in Ohio, but we do have resources that allow you to kind of create your own supported decision making plan that works for the specific ward. And that once again allows the ward to identify, not ward in this case, because there's not a guardianship going on, but the potential ward to identify different people that will help them make specific decisions. This is particularly helpful if the person only needs assistance in specific areas. So maybe they can make all of their home life decisions, but they need somebody to assist them in making financial decisions or medical decisions. Releases of information are also really helpful. A lot of parents, especially of transitional age youth who have developmental or intellectual disabilities, are concerned that once their child turns 18, they're no longer going to be able to be involved in their medical care. And that's just not true. Releases of information, as long as the child is consenting, are perfectly appropriate, and they will allow the parent to continue to schedule appointments, to be involved in appointments, and that sort of thing. Authorized representatives are also really helpful. You see this a lot in interactions with the state, such as with Medicaid and ODGFS benefits. You can designate an authorized representative to assist you both at your hearing and represent you in correspondence with the state agency. Protection orders can be really helpful if there is something that the ward needs protection, something or somebody that the ward needs protection from. So if there is somebody who is exhibiting a specific ongoing physical threat to the person, you could help the ward seek, or help the person seek a protection order that's essentially a stay away order and telling them that you can't have contact with this person at all. Powers of attorneys and advanced directives are incredibly important in continuum of supports for daily decision making. You can have a power of attorney and an authorized representative for so many different things in the state of Ohio. You can have a medical power of attorney. You can have a financial power of attorney. You can have an advanced directive that lays out all the kind of medical care you want to consent to while you have capacity. This is really helpful for people who have mental illnesses that may be cyclical. So they have times when they have capacity and they can make decisions for their health, but then they have times where they don't have capacity. And having that advanced directive allows them to make those decisions in advance, so that when they no longer have capacity, there's a record of what they said when they had capacity to make decisions. Additionally, advanced directives can also allow you to say, if I have to have a guardian, this is the person I would want to have a guardian to be appointed as my guardian, which can be really empowering as well. And then we get into some of the more court-involved procedures, such as conservatorship, which is a process by which the ward themselves approaches the court and consensually asks the court to appoint a person as a guardian to help them make decisions. And then they can revoke that at any time. And if they do revoke it, it can lead to a full guardianship, obviously. But it is a consensual process that is still court involved. Everything prior to conservatorship does not involve the court at all. And so it allows people to be really creative in terms of what's going to work for them in their specific situation. Another really great option that we talk about a lot is representative payees. So a rep payee you have to be determined to need one by the Social Security Administration, but this allows somebody to be appointed to manage, document, and report all of your benefit stuff from Social Security. It does not allow them to control anything outside, of your Social Security funds, but it does allow them to manage the benefits that you get. And also at DRO, we have a rep payee program. So if you believe that you have a rep payee who is not doing what they're supposed to do, who is exploiting you financially or somebody you know, and you want them to do an investigation, we have the ability to request that Social Security allow us to do an investigation to make sure that they're not being exploited in any way, shape, or form. And in the PowerPoint that should be in the materials, I have a lot of information about supported decision-making, what a supported decision-making plan might look like, as well as how to determine capacity, because that's one of the big things you're going to look at when you're deciding what option is right for you and your family. We talk about things called the stoplight checklist or the practical tool plan that allows you to go through the different areas of life that adults make decisions for on a daily basis and determine what areas the ward actually needs assistance with versus what areas they don't need assistance with, or they need very minimal assistance with. And so that can help you craft a really creative solution to capacity issues, as well as allow them to be in a least restrictive alternative. Because ideally we want, as Judge has said several times, we want the person to be making their own decisions. And the law in fact requires that if that is possible and safe, that that's what they be doing. And so that's the standard you're going to be held to if you choose to seek a guardianship. You're going to need to show that it's not safe for them to do any of these other options. And if the ward eventually decides to challenge a guardianship that has been appointed, these are all options they can use to show the court, this is the way I'm going to make safe decisions, and this is how I'm going to support myself in doing so.
Thank you. I would just mention on that topic also that just a couple things. One is that, obviously you want to be, if you're going to do a power of attorney, that has to be before the guardianship. A guardian is not able to, a ward is not able to sign a power of attorney after they're under a guardianship, and a guardian does not have authority to sign a power of attorney on the ward's behalf. So it's something that needs to be before that. And also, sometimes issues come up because just because you have a power of attorney doesn't mean that a provider or doctor is not going to reject that. So a guardianship may be necessary anyway. Some providers just insist upon that. So it could happen. But I would say also with Meg, one thing that we've seen helpful, a lot of times you're concerned about records. And if you're doing a power of attorney, I I would be sure to have a paragraph in there that is basically a HIPAA release that's enclosed in the power of attorney. So there's no issue about that. They don't, if you want the record, say, I have this power of attorney, they say, well, there's HIPAA. Well, I would put in there a HIPAA release in the power of attorney, so it's in there. That's just a thing. And I wanted to mention, I'm backing up a little bit, but I also wanted to mention on the guardianship application forms, those forms are all on our Lucas County Probate Court website. People talk about a packet. There's several forms have to be filed. You can go on the Lucas County Probate Court website. It'll have the forms that are the packet to file a guardianship, and you can print those off and take a look at them and see what information we need and go from there. That's kind of off topic, but before we left, I wanted to be sure everyone knew those are available on our website. I'm sorry.
No,
I appreciate that.
And Judge makes a really good point that if a guardianship is established, it will invalidate any prior powers of attorney or advance directives. So those will no longer be relevant. And if the ward does, or if the potential ward does have a power of attorney and a provider is refusing to accept it, that is a great time to call Disability Rights Ohio. We advocate for people to have their powers of attorney accepted as justifications for involvement on a regular basis, because if they can and they don't need a guardianship, we don't want people to have a guardianship established. So that's a great time to contact us, definitely.
Which I love. I love that's your stance. So that kind of leads into our next sort of two-part questions. One, we had an attendee ask, as a professional, how do you work with a parent or a caregiver and let them know that if they're planning on going for full guardianship, that it may not be in the best interest or idea for the adult child? How do you recommend having that conversation? And then as an extension of that, how is an individual able to, or are they able to terminate guardianship if it's no longer appropriate?
Yeah, so we talk about the stoplight checklist and the practical tool are really wonderful tools to have that kind of open conversation about what really does the ward need in terms of support. And it really makes you go step by step and determine, do they actually need help with making this decision versus can they make that decision on their own? And it also helps guide you as to whether or not, based on the way you answer the questions, guardianship may or may not be appropriate for that particular family. It is also good to have a conversation about the really positive outcomes we see for people who have more control over decision making. So we know that people who have control over decision making have better health outcomes. They are safer. They show better engagement in their communities, and they have longer lifespans as well. And so those are all wonderful reasons to really consider the alternatives to guardianship, on top of the fact that you are legally required to consider all of those alternatives and required to be able to show that none of those alternatives would be safe for the ward. In terms of terminating a guardianship, it can be really difficult once a guardianship is established to terminate that guardianship. That's one of the reasons why we encourage people to be really careful before they seek full guardianship, because that's potentially something that can be with the ward for the rest of their life. Now, they can obviously try and terminate guardianship, and we have been successful in helping people terminate their guardianships, but a lot of times they have to go through a bunch of hoops to show, yes, I have capacity. This is the things I'm going to do to ensure that I'm making safe decisions, and prove that to the court once there's already been a determination made that they were incompetent. And there's potentially years of documentation saying that they're incompetent, which can be really hard to overcome sometimes.
Yeah, I would say on that topic, on behalf of the court, that if you're trying to terminate a guardianship, it's almost the same as it is when you're establishing a guardianship. We're going to need basically an expert evaluation that some expert believes this guardianship is not necessary. We just have to rely on professional people with expertise in that area. And so in our court, we're mostly going to require a new expert evaluation. If someone in that field can say, in their opinion, this person the reason for guardianship no longer exists, then we will conduct a hearing. And once again, that'll be a very important part of that hearing, because you have to prove a guardianship is required by clear and convincing evidence. So, I mean, if we have one expert saying it's needed and one expert saying it's not needed, that's not clear and convincing. This is where we are.
So we are almost out of time. I just want to squeeze in our two final questions really quickly. And then so everybody knows, we will have this recording available on the website. And we will also have Maggie's beautiful PowerPoint presentation. I've had a couple of people message that they loved the visual. We will have that available as well with this recording on the on both agencies' websites. But We had one person ask, can you clarify how the ward can still be allowed to drive, marry, etc.? I'm confused as to how the ward has guardianship of person, but is able to make decisions that deal with that person.
Yeah, so guardianship of a person is essentially a legal term of art. It doesn't necessarily mean that you have decision-making power over everything that involves the person. It's just a way to differentiate the type of guardianship that involves medical and housing decisions versus a guardianship that only determines financial decisions. So under Ohio law, generally speaking, they retain any of the rights that are not explicitly granted to the guardian themselves. And there may be different cases where a court may say they are granted this, and a court can make a determination such as a right to vote that someone is specifically incompetent for the purposes of voting. But generally speaking, they are presumed to remain competent over those areas of their life.
Yeah, I would echo that also. And in those areas, I would say that it comes up in different ways. With regard to voting, we in my county in the last 30 years, we have never had anyone file anything to have someone declared incompetent to vote. I mean, personally, in my own view, whenever I have an election, I don't have any more elections, but whenever I have an election, everybody who votes for me should be disqualified. Who does not vote for me, in my opinion, should be disqualified from voting, but that's just my own personal. I will say that as far as a marriage, if a ward comes in and gets a marriage license, gets married in our court, we may not know that they're under guardianship from another county or something like that. The court does have the ability to void a wedding, a marriage of an individual, of a ward that was not consented to by the guardian. That would conduct a hearing, but I mean, this marriage may not be in their best interest. It may be somebody just taking advantage of them to get benefits through them. It doesn't really even know them very well. And we can void that. We can void a marriage, but once again, that doesn't happen very often either. But those things do come up.
Our final question that I'm sure a lot of people have is, are there any costs associated with obtaining guardianship or any of the alternatives, and are there financial resources available for those costs?
Well, I can tell you, once again, the courts, I'm sure the counties operate differently. In our court, if you're in Lucas County, generally speaking, to open up a guardianship has a deposit of $333. But in our court, we base a guardianship costs on the ability of the ward. And if the ward is indigent, we waive court costs. That sounds a little strange. Sometimes it is strange. You could have parents of this adult individual who, have extreme wealth, but basically, if the ward is without assets, we will waive the costs in our court as far as establishing a guardianship, and that would be the case mostly in individuals with developmental disabilities. We have other guardianships where people are just becoming elderly, and they have a lot of assets and they can pay court costs. But when we go by the assets of the ward, so most likely in these situations we're talking about today, our court costs would be waived.
There will, however, generally be a cost associated with getting the independent evaluation. And that can be a significant cost, and it can take a significant amount of time. Like I said, it has to be within 90 days of the original filing, but it also can take up to 6 months to get those evaluations done, depending on where you're at and the availability of providers to do those evaluations. And then you also may have the cost of an attorney. If it is a complicated case and you need to seek counsel, you may have attorney costs associated with pursuing the guardianship. Because a potential guardian is not granted the same right to court-appointed counsel that a ward is.
Thank you both so much. We appreciate you being here and taking time out to explain. I know we, even my department, we're eating up this information just because we are constantly fielding questions about guardianship, and it's such a tangled web, and you've really helped us untangle a lot of questions today. So we appreciate it. So we will have the recording once again on our website, and Lucas County Board of DD will have it on their website as well, along with the PowerPoint provided by Maggie. So Judge Puffenberger and Maggie, thank you, and everybody have a wonderful day.
Thank you. Thank you.
Thank you.
Thank you.